Thank you, everybody, for coming. I'm looking forward to this for quite some time. This is a webinar on how to protect yourself knowing rights as a tenant. And it's very important for those who are tenants, as well as those who work with tenants, work with people in housing and that. Fraud's been a real problem in recent years, as well as other tenant protections, and we're going to go through those maybe rapidly in that, but let's see how it goes. Kind of a unique training. I've never participated in a training like this. I've never seen one offered, but yet it's so important. It's kind of surprising. It's kind of hit and miss as far as people being able to enforce their rights as a tenant, and it shouldn't be that way. There's a lot of protections in Michigan law, but they're only as good as people having the knowledge that they're there and how to use it. Real quick on this webinar is being recorded. Questions go into the Q&A, not the chat, although there'll be some times where we'll be using the chat. And of course, the disclaimer, this webinar is informational only, not giving legal advice for specific situations. If you need detailed assistance, you can contact our office, 313-579-FAIR, or info@fairhousingdetroit.org. You can also reach us on our website at fairhousingdetroit.org, and you can send an email and upload documents, that kind of thing, on our website. For a closer look, the webinar will be posted under services and resources, and videos of other webinars are also located on that site. So again, big thank you to Mishta for sponsoring this webinar. And there's going to be another webinar coming up in later this month on source of income protection. So anyways, here's what we're going to cover. We're going to do examples of real estate fraud. We're going to steps to avoid fraud and other problems. We're going to look at security deposit, habitability and repairs, late fees, early termination of leases based on domestic violence and stalking, self-help versus the legal eviction process and the timeline for it, common defenses and eviction help, and Michigan's anti-lockout statute. Of course, time allowing, we'll go into question and answers, and then we'll have a list of some resources that are available for further information. I've got, let's see here, examples of real estate fraud, just a couple of them, just to show how widespread it is. And I just picked the eastern part of the state, Detroit, and the western part of the state, Grand Rapids. And this situation where a woman had a fake landlord scam, it's really a national news report, fake landlord scam, destroying lives in Detroit. Culprits or people that engage in that practices rarely face any kind of consequences for this conduct. And this involves June Walker. And I'm going to go right into the short video clip of her situation.
$15,000. That's how much June Walker says she paid for her house.
2 months after I made the last payment, I get this eviction note.
Now she's been told she doesn't own it. Tenants like Walker allege they've been scammed by individuals renting or selling properties they actually do not own.
Sometimes the real owner shows up with the police and says, "What are you doing in my home?"
Are there consequences for individuals who scam?
Not that I've seen.
Initially reported on by NBC's Aaron Einhorn in collaboration with Outlier Media. Cases include scammers collecting rent on foreclosed houses, renting vacant houses, or scammers filing false deeds and making fake sales.
It was so glad.
In Walker's case, she says she entered a rent-to-own lease agreement in 2019 with an option to buy, a big milestone for the 65-year-old previously experiencing homelessness and battling drug addiction.
I was running around the house all happy, calling everybody, "Hey, I made the last payment."
She says upon move-in, there was no furnace or water heater and a basement filled with sewage. How high was the water in this basement?
Okay, take a look at the side of this.
Oh, wow, that's like an exact example. So she renovated the home with money from savings and disability. Walker says she earned about $700 a month and paid $550 a month in rent to a man named Derek who said he owned the house, though his last name was redacted from a copy of the property deed he gave Walker. When did things start going wrong?
2 months after I made the final payment.
Walker made her final payment April 2021, but when she asked for the original deed, Derek eventually stopped responding. He was not the owner. Wayne County documents show RHMS Group bought the house for $8,500 at an auction in 2017, The group sold to Bacafe LLC, which ultimately filed Walker's eviction notice. In response, the lawyer for the company said, in part, the companies do not know who Derek is, and, quote, he had no authority from our clients to lease out or sell the property. The Detroit Police Department saying, in part, scammers are often not held accountable because they, quote, use fake identities, do not provide written leases, and use a middleman to commit a crime. Now, the grandmother of two faces virtual eviction hearing. But it's not just her. As more houses face foreclosure, Phillips says more tenants are at risk.
In the biggest way, it's those communities that are more on the lower income.
35% of Detroit residents live below the poverty line, leaving traditional pathways to home ownership out of reach, according to housing experts. Unless scammers are identified and prosecuted, advocates like Phillips say nothing will change. In response to the allegations, Wayne County Prosecutor's Office said in part that they sympathize with Ms. Walker's case, but that the county's mortgage and deed fraud unit did not receive a warrant request for this case. Walker's case currently remains in civil court. Now, with the federal eviction moratorium over, tens of thousands in Detroit are set to go through eviction proceedings, including June Walker, awaiting her final verdict in January.
Well, when I talked with the attorney last night, she said that we just needed to survive today. I know we have to, but it's not just about me. I think and wonder how many people have been through this. How many people just in Detroit alone have been played like that, man?
15th.
Here's one.
Tonight, Target 8 is exposing a rental housing scam.
Here's how it works. A real owner posts an ad online, and then a bad guy takes it and posts it somewhere else. He's trying to take your money.
Since we first told you about this story at 5 o'clock, more of you have contacted us saying that you were a victim.
24-hour News 8's Danny Carlson talked to one family who lost their money to a man in Nigeria.
The MTN number you are trying to call is currently switched off. Please try again later. Thank you.
The phone is shut off, and with it, the dreams of Angela Smith and her family. They won't move into their dream rental home tomorrow, and they won't get their $200 deposit back. Money they need.
It's really hurt them a lot because we thought everything was going together. It's not.
Flashback a few weeks. Smith found an ad on Craigslist posted there by a man who said he was a reverend who just got sent on a mission trip to Nigeria. But after a ton of emails and phone calls, something wasn't right. The man, who called himself Reverend John DeRuiter, wouldn't let them go inside the house, and he wouldn't send them the keys or a lease without a $1,500 payment.
He kind of sounded upset that I didn't believe him that it was his house.
So they did wire him a few hundred and stop by the house to check it out. But it looked more and more like people were living in the supposedly vacant home, and they were. Meet the real John DeRuiter. He just graduated from GVSU, isn't Nigerian, and he rents from the real owners, Bear Manor Properties. So here's what happened. The house was up for rent. The owners posted an ad online, and the fake DeRuiter stole it and tried to rent it out himself.
They can pull them offline off these various listings to just pull something out of the air and have it look legitimate.
And what about that whole religious angle? Phil Catlett from the Better Business Bureau says religion is pulled into scams like this one a lot more than you might think.
Religion, to some degree or another, is an emotional decision, and we tend to put some down of our defense barriers down when we're dealing with religious issues.
I feel this way. I don't want that to happen to somebody else.
In Grand Rapids, Danny Carlson, 24-hour News 8.
Tonight, Target 8 is exposing a rental housing scam.
One last example.
Monica, this is a weird one. So imagine you buy a house with the intent to fix it up, then rent it out, only to find out that someone else you don't even know has the same exact idea. And both of you have deeds. One has a key to the front door, the other has a key to the side door.
We got to the closing table, and as we had already wired our money, signed closing docs, a fraudulent deed popped up.
Here it is, that fake quitclaim deed, spelling errors and all, putting the sale of this $100,000 home on Detroit's east side in limbo for real estate investor Nader Sharif.
Party A in this fraudulent deed sold a property to Party B, whereas Party B doesn't realize that it's fraudulent. And so party B is now dumping money into this property because they don't know any better.
Sharif is on the other side, holding this legitimate warranty deed. But remember, Party B thinks they own it too, both paying separate contractors to fix it up at the same time.
We walked in and noticed that all the trash was removed from the backyard and the inside of the property. So that was a little confusing considering our keys still work. Come to find out, up till this day that I know of, our key still works from the front door, and they're using the side door as access where they've changed the locks now.
Sounds bizarre, but Sharif, who says he's bought and sold 200 homes this year alone, says it's an easy scam.
Anyone can draw up a quitclaim deed and record it. Does it make the sale correct or valid? No.
A quitclaim deed is different from a warranty deed, which costs a few $100s more, but ensures you actually own a property.
We have an owner who purchased it and was looking to sell it, who's now being told he's not even the owner.
Attorney Matthew Carey now ready to file suit against the phony deed folks. He says the same crew of bad actors keep pulling the same stunt in the city, and it's dissuading investors.
Unfortunately, in this city, it does happen more often than not, and it is a little bit turning into a little bit of Wild West.
Nader Sharif from our story there was able to track down the woman with the so-called phony deed, and she said that he will have to take her to court. That's exactly what he intends to do. The problem is courts are so backed up with similar type cases. It could be a year, if not longer, before this mess is resolved. Reporting live, Jessica Duknath, Fox 2 News.
So Jessica, people believe they've been a victim of a scam like this. Is there anything they can do other than file a civil lawsuit?
Right. So within Wayne County, there is a hotline monitored 24/7 for people to report this activity. But much like the courts, that department has their hands full. Best bet is to double down, report it on that hotline, and if you can afford it, go the civil route.
Yes, careful as possible.
So here's what we're, excuse me, here's what we're gonna do. We're gonna do a case study protecting yourself from being a victim. I want to clarify one thing that got mentioned on the previous video. There really isn't a $400 difference or so between a quitclaim deed and a warranty deed. The main type of deeds are quitclaim deeds, warranty deeds, covenant deeds are often used too. And if someone is doing a fraudulent quitclaim deed, they could just as easily do a fraudulent warranty deed or covenant deed. So don't be misled by the name on it. A warranty deed means that the person giving the deed to the purchaser or new owner is making covenants, promising good title and so forth. But if someone is kind of a fly-by-night person, fraudulent quitclaim deed, if they did a fraudulent warranty deed, that would be of no value as well. A warranty deed is only important when it comes to, for example, getting title insurance. A title insurance company is very unlikely to issue title insurance based on a quitclaim deed. They will prefer almost always a warranty deed, and they'll do a full title search before they issue title insurance policy. But typically it's very expensive to get a title insurance policy to check the title in that. So we're going to look at ways, kind of self-help ways to protect oneself from being a victim of any kind of deed fraud, mortgage fraud, lending fraud, that kind of a thing. Really focusing heavily on the landlord-tenant aspects of it. So our sample property is going to be 18600 Keystone Street in Detroit, and this property is being used for training purposes only, not intended to suggest or imply that there's any violation by the current owners, agents, management companies, or any other entities involved in the ownership or operation of this property. And here's kind of a quick little location of where it's located. So that's the Keystone Street property in Detroit. And let's see what we can find out about this property. We're going to first find ways to confirm title, confirm we're working with a legitimate owner, landlord, management company, verify rental certification, and importance of a written lease and why that needs to be done. So the way to do it, there's a couple of steps that you need to whenever you enter into any kind of real estate transaction. or any kind of rental transaction, to go to BS&A online and do a public record search. All the municipalities have BS&A. If there may be a couple that don't, I haven't seen them recently. But you go to BS&A, you can search by address, name, parcel number. It's a no charge to get, general information. For a small pay-as-you-go $3 fee, you can access more detailed information. Another step is going to the county treasurer website in Wayne County. Wayne County, just type in Wayne County Treasurer, and you go in there and you can search by property address and taxpayer name, and it shows whether property tax payments are current or delinquent. Another step is to go to the Register of Deeds office. Every county has it. You can go in person. For example, in Wayne County, on Monroe Street, you can go to Macomb County, go into their office. Most now have online access. Wayne is listed there. You can do it for Oakland County. Virtually every county, you can get online access as well. And then another step is to go to LAURA, the Michigan Department of Licensing and Regulatory Affairs, and you can do a business entity search. And once you locate a business entity, you can at the bottom of the screen will show all the filings by that entity, each of the annual reports, the articles of organization or incorporation. And then you can scroll through that and get more information on who's involved with that particular entity. Or perhaps it is not a properly registered entity within the state of Michigan, and that should raise some red flags for you as well. So here's an example for this property, the 18600 Keystone property. And this is what the free BS&A information reveals. It shows Diamond Anderson as being the property owner. At the top left corner, it has the parcel number for this property. Now, this is the free one. That's all you get under the free one. So it does give you the name of the property owner. So I paid the $3, and this is what I was able to obtain. If you look at it at the bottom, there's tax history, and it shows that the total taxes looks like they're paid. Everything has been paid on time. There's no amount due or owing at this time. And going through further with it, it shows the assessed value and so forth with it. And there's a little bit more. There's a principal residence exception on it. And here, there has sales history in the property. And we can see Diamond Anderson received it from Starman Investment Group, LLC. And it says MLC. I found later that's a memorandum of a land contract. So she bought this home under a land contract. At least that's what's reflected here. And Starmount Investment Group received it from City Mortgage, from a lending institution, and apparently looks like the Wayne County Treasurer, City Mortgage, received it from the Wayne County Treasurer. And it looks like it was previously owned by Doris Bailey, and there was a foreclosure that occurred. I'm not sure why the Wayne County Treasurer is involved in that. That would show that there were taxes owing in that. So it's kind of puzzling about that. And if you go back previously, there were other sales. The home previously sold for $37,000, $20,000, $37,000 again, and then $21,000. So it gives us some information, right? It looks like Starmount Investment Group, LLC, is doing a land contract with Diamond Anderson. On the far right side, it's got the LIBOR and page number. That's where the documents are recorded in the Register of Deeds. So you can access it that way. There's also general information as well for the $3 fee, information on the property, square footage, that type of information, whether it's 1 story, 2 story, and so forth. And then I then went to the Wayne County Treasurer, and it shows property address, 18600 Keystone Street in Detroit, and again, Starmount Investment Group, LLC. The Wayne County Register of Deeds office shows the memorandum of land contract and a quitclaim deed. It's got a little part where you can click on it and get a little bit more information on each of these documents. So when I search for Diamond, let me pull it here. when I searched for Diamond Anderson, these were the only two documents that came up, the memorandum of land contract and a quitclaim deed. The quitclaim deed is, I think I show it in a later screen, it's for a different property. So the only one for this particular property is the memorandum of the land contract. And this is the quitclaim deed. If you look on the bottom right, it says 14922 Louder. So that's a completely different property. Looks like she bought that from the Detroit Land Bank Authority. And here's the memorandum of land contract. This is all free of charge from the Register of Deeds office. It shows when it was recorded, July 17, 2020. There are 4-page memorandum of land contract. It's 4 pages. It shows the book and the page number, or library and the page number. And it was handled through Fairlane Title Agency. And a lot of interesting things in there. It even gives you the name of the notary. I've been involved in cases where there's a fraudulent notary, and the deed fraud unit was investigating the notary. One time there was one where, believe it or not, they forged the notarization and made up a bogus notary name. So they're capable of all kinds of fraud in real estate transactions. So I did one more step. Even though if you look at the property here, Diamond Anderson is listed as the grantee. There's Starmount Investment Group. So I did a search for Starmount Investment Group, and turned out it's not registered with the state of Michigan. So based on that, I would be very, very concerned in having a business dealing with Starmount Investment Group. Yeah, I don't know if the owner entering into a land contract with a entity that's not even registered with the state. Well, they need to be registered with the state. That's the problem. So that's getting the information on the property. Again, I have a red flag on this one because of Starmount. Also, there's a need to verify the rental certification. I just picked Detroit, Grand Rapids, and Southfield just by example. You can get those online. Detroit, you can put the address in, and it'll pop up whether the property has a rental certification. Grand Rapids gives a long list of properties, like almost like a big PDF file with all the registered properties. And Southfield has that information too, only Southfield is listed on the BSNA website for a particular property. It'll show whether that property has a certificate of rental certification. So I did it for this property. I typed in 18600 Keystone Street in Detroit. Turned out that it is not registered. Now, I don't know if the person that's buying it under land contract is then renting it out as well, or living in it herself. I really don't know. If, possible, if she's a land contract owner living in the home, it wouldn't be required to have a rental certificate. But if she was then renting it out to someone else, this property is not registered and it's not certified, hasn't been inspected, and hasn't gotten a rental certificate. So that's important to know. So you get a lot of information. That's a real first step for people to protect themselves, to make sure they're dealing with legitimate owner, landlord, management company, and so forth. Otherwise, facing risk. And I don't, the scenarios that we saw, I don't know what kind of search were done, a couple of videos to really confirm the information in terms of that property. One of the videos did today where I think the gentleman said, well, turned out one person, suppose a purchaser had a key to the front door and it was sold again, and someone had a key to the back door. If those were all recorded as to a particular property, that would show up on the BSNA. There would be extra deeds and transactions in there, which would be a red flag to someone. And I think what happened is he showed up at the closing table and found out there was a problem with the title to the property. He shouldn't have just waited till the closing, should have checked it very early on, right? But that's when the problem really got highlighted, because the title company did a record search. Well, we kind of did our own public record search by just going through Detroit BSNA, going through a Wayne County Treasurer, and then going through the Wayne County Register of Deeds office. So there's things that you can do. Again, if you want more detailed information, you could go down to the Register of Deeds office and actually look through the documents themselves. Wayne County or Oakland County, for a small fee, you can actually download full documents. I think it's a certain small fee, and it doesn't mean the document could be 30 pages and you only pay the same small fee regardless of the size of how many pages there are. Real quick, and then we're going to go through a couple have some Q&A question on this. What are unlawful lease provisions? The Truth in Lending Act has various provisions that basically prohibit certain kind of provisions. Is not allowed to accelerate rent. The landlord can't say, well, all the rent is due pay, you know, the remaining payments for rent on the remaining term of this lease are due and payable right now. They can't accelerate it. They can't waive any rights under the Anti-Lockout Statute or provisions that exempt the landlord from liability for their own negligent act and so forth. Doesn't have a lot of remedies. The tenant has to give the landlord written notice. The landlord has 20 days to fix the language in the lease. And again, the Anti-Lockout Statute kind of says the same thing. It overlaps with the Truth in Lending Act. Doesn't allow you, they can't waive their rights, or tenants' rights under the Anti-Lockout Statute can't be waived. I haven't seen a lot of Truth in Lending Act claims being raised. But here's a couple of things. Advantages for a written lease. Two key sources of information. There's a practical guide for tenants and landlords. Michigan State University puts it out in its kind of association with the Michigan legislature. And there's a landlord tenant bench book. I have those links at the bottom of the PowerPoint. But here's what it says on advantage to a written lease. Certainly, you can do an oral agreement for a lease, provided that the oral agreement or the oral lease doesn't last more than a year. If it's more than a year, it's required to be in writing to be valid. There's no option if the lease is going to be for greater than 1 year. And why do you want it? You want a written record of the transaction so there's misunderstandings as to what the arrangement is for rental of the property. And again, what to look for before you sign a lease or someone signs a lease, you want to make sure and confirm you're dealing with an actual owner of the property or reputable management company, as we went through, and that the property has been inspected and has a current rental certificate. Another key one is that all repairs have to be fully completed. People get into problems because they're going into properties with the landlord promising that the repairs will be done or the owner promising the repairs will be done. They're not being done. If they've not been completed prior to moving in, don't hold your breath thinking they're going to be done after you move in. There's not much incentive at that point for the landlord to make the repairs. The lease should state who's responsible for utilities, what those amounts are. It should specify what you're renting. I see people have problems because they rent a home and then they want to go put something in the garage and the landlord has all his stuff in the garage, or he's going back and forth into the garage. And you say, well, wait a minute. I thought we leased the whole property. Well, yeah, it should state, and you should understand that whether or not the garage is covered. There have been issues with problems with the basement. Landlord not clearing stuff out of the basement, or then renting the basement to someone else, and you thought you rented the whole home. So it's real important to know and have that specified out exactly what you're renting and not renting. I mean, certainly very, very important to know, right, if there's going to be someone living downstairs in the basement. Another one would be, for example, someone living in the basement and then not paying utilities. And, your lease says you pay utilities. Well, yeah, you thought you were paying utilities for the whole home, but you didn't know someone would be living in the basement without paying utilities. Late fees must be reasonable. We'll talk about that. And then I always recommend do not agree any provision of lease that the tenant has to pay the first $100, $200 or more for any repairs. They put that in there because maybe the tenant is cash strapped. They're not likely to claim or want repairs done if the first $100 or $200 has to come out of the tenant's pocket. And determine that you have a records of all payments made, whether it's security deposit or any other payments. You've got to get records. Just a real quick question in the chat. How would you make sure you're dealing with the actual landlord or owner of a property? What would you do to confirm that? You can type it in. What steps would you take? Aaron, England, you guys could put something in too. Yes. Check the property on BSA. Absolutely. And that's why BSNA is there for us. Check out Laura. Yep. Or Wayne County. That's a good step. And as Aaron pointed out, checking on Laura, we do it all the time to check on the business entity. So, yeah, I've, even going further, go right into Laura and look at the corporate documents for an entity. It's very revealing. And you can see, you get the names of the people that are involved. They're not likely to file false statements, corporate paperwork with Lansing. So these are all real important steps. And again, before, if it's a land contract type situation, you actually, before you enter into land contract, you want the seller to obtain title insurance and have a deed put into escrow at a minimum. But often that's not even done. People see that there's title problems much too late after they've already paid a lot of money. And it's very difficult to then do a civil action and seek to collect. It's better to not be a victim rather than be a victim and attempt to then collect on what you had to pay. So let's talk a little bit about security deposits, the importance of inventory checklists, the limits on security deposits, what kind of deductions can come from security deposits, and the security deposit timeline, and whether the landlord can waive the right to security deposit, the tenant's right to recover double damages, and how to file a claim. So inventory checklist is very important. It confirms the condition of the property when the tenant moves in. The ideal is this: make sure from a tenant standpoint, really a landlord too, that you have a inventory checklist that you carefully completed, listing anything, any damage, anything problem with the paint or anything. Also, do a video or photos or video recording of the unit, regardless of whether you're a landlord or a tenant. And the tenant then, I realize this, the tenant can ask a copy of the inventory checklist of the previous tenant, the move-out checklist. And if requested, the landlord must provide a copy to the tenant. So it is proof, because if you don't get that and you don't record the condition of the property at the time you move in, then what? Then you're really susceptible to what the landlord will say that you damaged. So it's real important. It will be very important for a court to see that. Security deposit, the rule is that it cannot exceed 1.5 times the monthly rent. Any prepayment of rent other than the first full rental payment period, first month's rent not considered part of a security deposit. The first month's rent is just that, first month's rent. But if they have you say, hey, you need to pay the first month's rent and the last month's rent to move in, well, then the last month's rent counts as a security deposit. But sometimes they'll do, 1.5, they'll say you have to pay the first month's rent plus 1.5 times a rent payment. That's all that's allowed, right? Additional fees, keys, mailbox storage, etc., count as regular fees, but if they can be refundable, then they get added into the security deposit. Non-refundable fees are not part of the security deposit. But again, they have to make sure that those fees charged are reasonable. Here's permitted and charges that are not permitted. A landlord can charge front-page utilities, electricity, water bill, etc., provided that it's in the lease, that it's the tenant's responsibility, and can also charge for damage beyond reasonable wear or tear. What about administrative fees? Yeah, that's a question about that. Someone asked about in the chat about administrative fees. Like, why, is it in the lease? That'd be my question about administrative fees. If the administrative fees are in the lease, yeah. If it's not in the lease, no. I don't consider that. That's probably not a reasonable charge. What would be the administrative fees? Why would a landlord need to charge administrative fees? Right? That's just a fee they're throwing on. They're getting a rent payment. That should suffice for what a landlord needs. Charges not permitted. And this Smolin case is very important. It said that charging for general cleaning and carpet cleaning violates the Michigan Consumer Protection Act. And the Michigan Consumer Protection Act is violated when the landlord retains part of the tenant's security deposit for cleaning, and it provides for actual damages or $250 in statutory damage, whichever is greater. Question: do you think a landlord can charge a tenant for painting? Why or why not? What do you think? Is that reasonable to charge for painting? Yeah, Sarah said, if it depends, if it's for damage, right. If it's just the general wear and tear, or just, yeah. If it's just regular maintenance, like the paint is old or something like that, no, can't charge. If there's been a damage to the wall that requires painting, like Ingela points out, right, then they can recover for the painting. We have a case pending where a woman lived in a unit 31 years. It had never been painted, believe it or not. And they wanted to charge her when she then transferred to another unit. They wanted to charge her for the painting fees. Transfer a unit and to charge her for the painting. Other than that was on $2,000, believe it or not. They had to pay $2,000 to move to a different unit. So that's violates, right? Michigan Consumer Protection Act. That's not a permissible charge. So yeah, it's important for people to know it. If they don't, they will typically end up just having to pay it without knowing that that's not required. Court costs and attorney fees, they're not allowed to charge more than the attorney fees provision permitted by statute, which is $75. That's the full amount that attorneys are allowed to charge, or landlords are allowed to charge a tenant for attorney fees. And also clauses claiming to right to attorney fees or to evict without a court order are also prohibited in residential leases. For example, a landlord will refer an eviction case over to an attorney, but the case never gets filed in court, and then they're going to put a $75 or $125 fee on the I don't know, log or statement for the tenant, even though it never went into court. They're not allowed to do that. I see it time and again. That's not legal. That's a violation of the Consumer Protection Act. Here's the security deposit timeline for the beginning of the lease. And this is from that practical guide on landlord tenant in Michigan. And it shows the security deposit, has a section of the statute, the landlord's duties, and the tenant's duties. Beginning of the lease, again, the landlord is, can't exceed 1.5 times the monthly rent for a security deposit. The security deposit is lawful property of the tenant, supposed to be kept in a bank account. Within 7 days of move-in, the tenant then has to return the landlord a completed inventory checklist, and the landlord has to keep the checklist. Within 14 days from move-in, the landlord has to provide the tenant the landlord's name and address for receipt of rent and other communications. Typically, that's going to be information going to be in the lease anyways. The landlord's supposed to be telling tenants where the security deposits are being held, and specific notice to provide for tenants to provide the address to 14 days after they move out. We'll come back to that later, but there's not been a lot of compliance with that. When it comes time from move out to 45 days after move out, the landlord has to complete inventory checklist, noting condition. The tenant of course, has to remove their items. The real key one, should have put a mark on it. The landlord must provide the landlord in writing, not orally, the forwarding address within 4 days. That's critical. That will put on the landlord the obligation to get the next step, 30 days after move out. The landlord has to mail to the tenant an itemized list of claimed damages that for the landlord to take portions of the security deposit. The landlord then has to provide an itemized statement. And then with 7 days of that, the tenant has to respond by ordinary mail, they have to do a proof of mailing, a response to what the landlord is claiming for damages. And then within 45 days, not thereafter, the landlord has a deadline to file suit against the tenant for damages, unless there's some exception that applies. For example, if the tenant doesn't give a forwarding address, things of that nature. It's so crucial. If suit is not filed, again, what can the tenant do? If the landlord doesn't file a claim, then the tenant can then file suit for recovery of the security deposit. Typically, how that works is the landlord's failure to comply with any of the previous provisions, that's MCL 554.613, entitles the tenant to double the amount of security deposit retained. Typically, that claim will be filed in district court where the property is located or where the landlord lives for amounts up to $6,500. That can be $6,500 up to $6,500. The tenant can do an affidavit and claim filed in the district court small claims division. Claims over $6,500 should be filed in the general civil division of the district court. Here's an example of objections to itemized list of damages that I prepared in a case. If you look at it, there's Larry landlord's position. He was asking for legal and court fees, $135, late fee, $100, water reimbursement, $296, rent for January 2021, replacement of locks, $100, replacing windows, $200, and then he subtracted from that the security deposit, so he wanted $406.61. The tenant's position was this: legal and court fees. These were not warranted because all of this occurred because the landlord failed to provide heat and safe workable stove. With the late fee, same reason as above, contesting that. Water reimbursement, well, there were problems with the drain and the water and problems with the plumbing, which caused excess water to be used. And so the reasonable amount was just $117, not the $296. Then rent for January and December is a great, detailed statement there. The furnace stopped working. There was also a problem. The furnace was putting elevated CO2, carbon dioxide levels in the home. The family didn't realize the tenant and her daughter were sick from that. There was also the city, they get a complaint to the city about the furnace, and there's a problem with the stove. The city stamped on December 14th due to the condition of the furnace and the stove. The city building department tagged the home as uninhabitable and requiring the person to contact building department before entering. So all in all, it was a dangerous situation. It was the DT inspector described the home as dangerous and so forth. So it's a great detail about all that occurred. Because it wasn't kept habitable, we're going to see there's a right to rent abatement for both December and January. So even though the $850 rent was paid in December, that should be credited back to the tenant because the property was uninhabitable. And then down there under, it's not a line there, but it says 250, that's statutory damages under the Anti-Lockout Statute. Replacement of locks, landlord specified there could be not more than one key. And so there was slide door missing. So the landlord had the permission, we got the permission, there's an explanation about the replacement of locks, but that was done with the agreement of the landlord. The replacement of the windows and trim missing. House had 4 windows and screens at the time of the lease, so that's not entitled to that. And the security deposit, the parties agree a security deposit will be offset against charges returned to the tenant. So anyways, by the time you go through all of this, the landlord owes her $2,258. So that's a different scenario. The landlord in this situation did not file in court to claim damages for the 406. And so instead, after the 45 days passed, then the tenant went into small claims court against the landlord. I changed the names and property address, of course. And so The date that it arose was December 2020 through March 2021. The amount claimed was $4,500. The reason that that was increased from the previous amount was because there was now $2,550 for double the $1,275 security deposit because the landlord did not return the unused portion of the security deposit. Then there's also still the statutory damages, and then there's the rent abatement of $1,750, $850 each for December and January because the property was not habitable. So that's what gets filed. That's all you have to do. And I wish more people did it when it came time to recovering for their security deposit. Any questions so far? Go real quick on rent increases. Generally, no limitation on the amount of rent that a landlord may charge, but if it's a fixed lease for a year, for example, rent can't be increased during the terms of the lease. There is a provision which says the landlord may not charge a rent which is grossly in excess of rents for similar houses or apartments. That's a protection under the Michigan Consumer Protection Act, meaning people engaged in business with consumers can't charge grossly excess fees or expenses. That would be a violation. So that'd be a violation of the Consumer Protection Act. Michigan law doesn't allow rent control ordinances that you see, like for example, in cities like New York City that have those. They're not lawful under Michigan law. And there's a couple other ones. I'm not going to go into detail here. There's Michigan Regulation and Taxation of Marijuana Act, the purpose of it. So I put it in here because it says a lease agreement may not prohibit a tenant from lawfully possessing and consuming marijuana by means other than smoking. And then Michigan Medical Marijuana Act cannot be required to require a private property owner to lease residential property to any person who smokes or cultivates marijuana on the premises if the prohibition against smoking or cultivating marijuana is in the written lease. That's a couple of things that come up quite a bit. Anyways, what's one thing that you learned about security deposits today? Something you didn't know? Anything new? What would you think about security deposits? Anything different that maybe you were not aware of with security deposits? Any rights when it came to security deposits that you were not aware of? Yeah, comment that there's specific time frames, 7 to 14 days, and that things that are required in terms of providing an inventory checklist, providing information, specific information as to the amount of the security deposit. As a comment too, a good one. When a landlord is foreclosed, they still owe you your security deposit back. That is true. Right. Yes, and you can ask for a copy of a checklist. Very important. And I'm not sure people know that. Not only that you can ask for a copy of a checklist, you can ask for a copy of a checklist from the previous tenant. It's very important. All right, another important one is habitability. And again, it's important that repairs are completed prior to the tenant signing the lease, paying a security deposit, or moving in. Requirement of habitability for a landlord and meet all health and safety laws, have the property repaired, and navigating the repair and deduct process and retaliatory eviction. Michigan has it by statute. Doesn't matter. It says the covenants of habitability apply to every lease of residential property. And it's basically the landlord or less or covenants, all the premises, the unit, and all common areas are fit for the intended use by the parties, and to keep the premises in reasonable repair during the term of the lease, comply with all health and safety laws of the state and local unit of government where they're located, unless it's caused, of course, by the tenant. And the provisions are liberally construed. The privilege of a prospective lessee or licensee to inspect the premises does not defeat the right to have the benefits of the covenant. In other words, the landlord can't say, well, you had an opportunity to inspect, you knew there was a problem with the elevator. Well, that's your fault, No, can't do it. Still, the obligation is on the landlord. So it's very, very important with this. Notice too, comply with health and safety laws of the state and local government. If they issue a notice saying that there's violations that need to be corrected, well, that's per se a violation of the covenant of habitability. Damages resulting from the landlord's breach, just a terrific provision. If it's found that the plaintiff, meaning the landlord, is entitled to possession due to non-payment of rent, the judge or jury making the finding shall determine the amount due in arrears at the time, which shall be stated in the judgment. So I don't know, $1,000 a month, they owe for 2 months, $2,000. But in determining the amount due, they have to deduct a portion of the rent, which the judge or jury finds excused by the plaintiff's landlord's breach of the lease or breach of one or more statutory covenants imposed under 554.139. 554.139 is that covenant of habitability. It is required in every case, any eviction case, in residential property, that the landlord show that the property was kept habitable. Eviction hearings flow through the courts, and in many of the courts, they really don't examine this, but it is a requirement. Another factor too is the repair and deduct. There's both statutory and common law. The statutory right to repair and deduct is in the Michigan Housing Code, MCL 125.5345. If the landlord fails to make repairs, the tenant may have a statutory right to make repairs and then deduct the costs from the rent. Of course, the tenant can't be the cause of the condition. There was also that right under common law in the Anchor Inn of Michigan versus Notman case. And I really never looked close at it, but that one just had the right to reimburse the tenant for repairing a defective air conditioning unit. And so that's the same thing. So it's both statutory and common law. Common law just means through court decisions rather than a statute passed by the Michigan legislature. Here's the question though. The repair and deduct process is high risk. The tenants need to follow the best information I can give is, we drafted our own kind of short one-page repair and deduct, but I don't think it's as good as what you get in the Landlord Tenant Practical Guide at pages 26 to 28. Tenants need to follow that exactly. It gives great guidance in navigating through the repair and maintenance requirement. And it talks about types of maintenance problems, emergencies, major problems, minor problems, the landlord's responsibilities, and when the landlord is required, depending on what? The nature of the problem, whether the landlord's duty to repair has been modified either by the tenant's conduct or by mutual agreement. Again, I do not recommend that any tenant take on the obligation to do repairs to a property. And so forth. And so when the property is not being maintained or repaired, right? It lists the tenant's responsibilities, right? Pay the rent on time, keep the rental property in safe and sanitary condition, promptly notify the landlord of any maintenance problems, and do it in writing and keep a copy of it. Text, email, certified mail, and then leave the rental property in good condition. So to solve the problem when the repairs are not being done. Step one, notify the landlord and provide a reasonable time for repair. You can't say, oh, fix it in 2 hours. That's not going to work. It has to be a reasonable amount of time. Then, second step, right? And it does invite a keep copy of all the communications. contact the building inspector and schedule an inspection. Very crucial. And then if the step 3, you want that because that's reported by a government official. I know Detroit's building department, they will provide a copy of their inspection report to the landlord. They will also provide it to the tenant. They will not provide it to any third party. So you have to show the building department that you're a lawful tenant, and then they will give you a copy of it as well. And that's very, very important because if the violations are found, a court's not going to say that, oh, the building department was wrong in finding a violation. Very unlikely. They'll accept that as proof that repairs needed to be done. Step 3, if the landlord still fails to make the necessary repairs, can either withhold the rent and deposit into an escrow account or pay for the repair and deduct it from the rent. I recommend here is put 2 or 3 estimates, reasonable estimates, provide those to the landlord and put the reasonable amount for the repairs, put that into an escrow account, a separate bank account, and not your own account, put it into the escrow account, give the landlord notice. It could be $800, it could be $1,500, it could be the full amount of rent that is being put into an escrow account. And then deduct only from the rent as much as should be done to cover the repairs. What the issue, though, is often that when the tenant withholds any part of the rent, a landlord may start the eviction process, and that's a concern. If that occurs, the tenant can claim retaliatory eviction, or as well as that the landlord breached the warranty of habitability and the duty to repair. And again, to show that the rent was withheld and put into an escrow account will help as well. Not that it's just sitting in the tenant's own account, that won't suffice. Here's a quick question. What does it mean that a property is not habitable? What's the standard for habitability? Is there one? Maybe jumping ahead a little bit with this question. And what's one way Tanisha tenant can deal with property that's not habitable? What would you recommend? The landlord hasn't been doing, yeah, heat or air conditioning is not working. Would that be one? I think Lila is correct because that's the one the court mentioned about air conditioning. And actually, we're going to get to it in a few minutes, but the anti-lockout statutes, when Lila mentioned heat, failure to provide heat is a violation. In fact, it constitutes a lockout of a tenant who, especially, a place like we are in the north where you have cold winters, right? What about, what others would you say? What about hot water not working? Would that be a problem? Would you say hot water? Yeah, those are all things that would be running the property not habitable. Let me do this. We jump to this. Right here. I jump ahead a little bit, but the anti-lockout statute lists types of violations, and it's got use of force, removing, destroying a tenant's property. It's in the middle when there are types of violations. But look at 6. Interrupting or terminating utility service that landlord is under a duty to furnish involving an essential service such that failure to provide constitutes a constructive eviction, such as heat, running water, hot water, electric, or gas service. So that would be one that would constitute that. In the case we showed earlier, where there was CO2 level too high or problems with the furnace, that has to do with what? Heat, gas service, right? Little mention about heat, air conditioning. Notice air conditioning isn't mentioned, but it is mentioned in the Michigan Court of Appeals decision. So that would be covered. Another one, introduction of noise, odor, or other nuisance can also be a violation of a lockout statute. But I would say these types of violations of the lockout statute also constitute situations that render a property not being habitable. And again, it entitles someone to rent abatement during the period that the property is not habitable. So there are, avenues for relief for people. So let's go through late fees. Are there limits on late fees? Well, what are they? And any restriction on recovery beyond the landlord's actual cost? Late fees have to be reasonable. There are municipalities like the District of Columbia where they have established by ordinance, for example, in DC, there's a 5% limit on late fees. It also says that a landlord cannot move to evict a tenant based solely on late fees. It has to be unpaid rent. But without that, in Michigan, we don't have that clear guidance just yet. I think at some point we will. But late fees have to bear a relationship to the actual cost incurred by the landlord because the late rent came in late. And it's up to the landlord has the burden of establishing reasonableness. If a court finds that the late fee is more like a penalty or liquidated damages clause, it can be invalidated. Okay. And the city of Detroit, for example, on its website says excessive late fees can be rejected by the court. Typical amounts over $35 are worth raising. I like that. Good for the city to do that. Unfortunately, on many courts, they take $50 late fees or $100 late fees are perfectly fine as a matter of course. Even though the landlord may not have incurred fees or costs of $50 or $100 because the rent check came in 2 weeks late or 3 weeks late. In the chat, let's take a situation. Larry landlord charges Tanisha tenant late fees of $10 a day. The $10 a day late charge is contained in the lease. Is this proper? If not, how would you address it? What do you think about late fees of $10 a day? Have you seen it? What do you think? Do you think that's a reasonable amount? Aaron says no. Why is that a problem? What has to be shown for a late fee? Right, it'll add up to $300 by the end of the month. Absolutely. Is the landlord, if the rent is late, let's just say it's paid after half month or whatever, 15 days. So that'd be $150. Receiving the rent 2 days late, what kind of damages do you think the landlord sustained by the late rent? Do you think it cost the landlord $150? Right? Probably not, right? Here's the problem with this. It's not easy to address it. So what does the tenant do? The tenant then pays the regular rent and then what? Maybe pays a reasonable portion of the late fee, maybe following what the city of Detroit says and going back to $35, the rent plus $35. And then what would the landlord do? Well, I'm sorry, you still owe. You can see the problems that occur with this. So there's really not a great mechanism to address this. And that's why tenants feel that they're really under the gun and they end up paying it, not challenging it. We just need some guidance, either from the state passing some legislation or maybe at the local level, something to address it because it's a real problem for people. And I can't tell you how many times I've been in, landlord court, and it's really not raised. I mean, I've seen late fees of $200 accepted. Yeah, English is a good point. Late fee has to correlate to the actual cost. It must be a reasonable amount. That is so true. So it's not an easy mechanism to take care of it. Just real quick, early termination due to domestic violence and stalking. Michigan has a statute provides for early termination for tenants or their children who are in reasonable apprehension of danger of domestic violence, sexual assault, or stalking. And it's set forth in the statute. It's technical. People have to comply strictly with it, including getting a notary statement verified by a qualified third party. We have the form in our system to help people prepare it. But it has it right in 554.601B, has a sample notarized statement that someone can then prepare. It releases the tenant from the obligation to pay rent no later than the first day of the second month that the rent is due after the notice is given. So if the notice went out today, it'd be the first day of the second month that the rent is due after the notice is given. I believe they would still be under the obligation to pay rent, but the April rent has already been paid. May rent would have to be paid, and then they would be released starting June and thereafter. So it's not immediate, so they still have to stay in for another month. It only applies starting on the second month. Another one is VAWA, Violence Against Women's Act, has to do with applicants and tenants of HUD housing programs, victims of domestic violence, dating violence, sexual assault, stalking. There's also provisions on it where it at the bottom grants protection to abused spouse or child of a U.S. citizen or lawful permanent resident, including the right to self-petition for a green card. And it's not limited to women, even though the name says it. It's available all regardless of sex, gender identity, sexual orientation. And the landlord may not consider incidents of domestic violence, dating violence, or stalking as serious or repeated violations as good cause for termination of the occupancy rights as to victims of abuse. And again, it's fair to protect victims as well. The landlord may request in writing that the person certify the person is a victim of abuse. And there's a form, 91066, that gets prepared, submitted within 14 days to receive protection under VAWA. Failure to provide it within the time frame could result in eviction. So those are important as well. These come up quite a bit. So real quick on the eviction process, there's no right to self-help. We're going to look at territory eviction, eviction timeline, notice of defenses, and then financial assistance and diversion programs. There is no right to self-help. Very early on in Michigan, eviction statutes were drafted because they didn't want landlord self-help. In other words, somebody bringing people out or bringing big people out to throw tenants' possessions out of the unit. There were violent confrontations between tenants and landlords and tenants. And not only that, it prohibits a landlord from resorting to self-help even when the landlord is entitled to possession. Even instead, the landlord must, if the tenant doesn't voluntarily vacate the premises, has to use the judicial process. And to discourage self-help, if the landlord uses forcible, force, assault, that type of things to remove a tenant from a property, then the tenant is entitled to treble damages and actual damages under the Anti-Lockout Statute. Also, if the landlord uses self-help, the landlord will lose their right to obtain a judgment of possession. The couple important provisions on it, if you look at MCL 600.5721, a landlord can't get a judgment for possession if any one of these things are established. The lease termination is intended primarily as a penalty for defendant. That would be the tenant's complaint to a government authority with report of a violation of a health or safety code or ordinance. Another one, for example, there's one where tenants can form a tenant organization. You can't be evicted over that. Or you can't be evicted because the landlord committed a breach of the lease, which excludes his payment of rent if rent is claimed for non-payment of rent, meaning if the property hasn't been kept habitable, the landlord can forfeit their right to get a judgment of possession. Then under retaliatory conviction, there's a presumption. If it's shown that the landlord has moved to terminate the tenancy within 90 days, and it's shown that within 90 days before summary proceedings are started, the tenant attempted to enforce rights as provided above, for example, made a complaint to the building department or other type of a complaint, and then it will be a presumption that it's a retaliatory eviction. If the complaint by the tenant was made before 90 days before the commencement of proceedings, right, then the presumption is not there. In fact, the presumption adverse to retaliatory eviction arises, and the defendant tenant then would have the burden to establish the defense retaliatory eviction by a preponderance of the evidence. So if they move to evict within the 90 days, it's a presumption of retaliatory. I don't bog down too much on that because, for example, someone makes a complaint to the city and then 2, 3, 4 months later, they non-renew the tenancy. It sure looks like that was a reason. Here's one. Tanisha tenant called the building department. The building department found violations by Larry landlord. Larry has not given Tanisha notice. Oh, it should be, I'm sorry. Larry has, I'll fix that. Larry has given Tanisha notice that her lease will not be renewed. Can Larry do this? Or what else would you need to know? Tanisha called the building department. Building department found violations by Larry. Now Larry just gave notice that her lease will not be renewed. Can he do this? What do you think? What else would you like to know? Does that look like retaliatory eviction? Retaliatory non-renewal? Yeah, Aaron, good point. You need to know when she filed the complaint, when she filed the complaint with the city. Yes. When she received the eviction. Yeah. And so is it the notice of non-renewal or is it the start of the eviction case? Say the non-renewal. If I go back and look at this, it says under retaliatory eviction, it says within 90 days, I can make a highlight on it right here. It says within 90 days before the commencement of the summary proceeding. That's the filing of the case in court. So the operative date is just the notice itself probably won't be. So in this situation, it doesn't mean you can't claim retaliatory eviction. It just means there's no presumption. To get the presumption, you have to match up, like Aaron points out, when she made the complaint to the city and when the eviction complaint was filed with the court. Those are the two key dates in order to decide whether or not she gets the presumption of retaliatory eviction. Even though she doesn't show that the complaint actually got filed just yet, and if it happens to get filed more than 90 days after, maybe her lease will not come up for renewal in 4 months, and he just lets her know early, look, I'm not renewing you now. Knowing obviously what she did, because you made a complaint against, Larry landlord. But you can still argue retaliatory eviction or retaliatory non-renewal without the presumption. You just don't have the presumption. In fact, the landlord could say, well, there is no presumption, and, you know, good luck arguing that. You know, the key factor is, well, how much time passed between when you knew she had gone to the city and when you issued the non-renewal? As a factual matter, I still argue that that's retaliatory. And again, it's the tenant's right to make those kind of complaints. Nobody likes a complaint filed against them. Obviously, none of us do. Nobody ever does, but it's the tenant's right. Fix the property. That's what the landlord should do. Not, I'll fix it grudgingly and then get another tenant. That's not the way it's supposed to work. So it just illustrates that it's a challenge sometimes proving retaliation, even when it's occurring. And this is not some hypothetical situation. Time and again, tenants are afraid to make any complaint because they feel like they're going to be put out. And that's true. They're afraid to have to go through and assert it in court. So they just let it go, and they take a lot of abuse. And they live in unhabitable housing. Real quick, here's the eviction timeline. It has the notice. There's 24-hour notice is required for illegal. There has to be an incident giving rise to eviction, 24-hour notice for illegal drug activity, and a formal police report filed. Has to be a police report filed. And the provision must allow for termination. There's 7-day notice for non-payment, extensive and continuing physical injury to the property, serious and continuing health hazard, injury and threatened injury to another person. The first 3, non-payment of rent, physical injury to the property, health hazard, those are fixable by the tenant to stop the eviction process. They better document that it's fixed. Then there's 30-day notice for non-renewal, violation of the lease provision, holding over after expiration of the lease term, just cause, if it's a mobile home park. And then after that time period is passed, the 7-day, 24-hour period, 7 days, 30 days, if things cannot be worked out, then a complaint gets filed. Some of the complaint gets filed in court. Landlord's duty, about the notice and how it must be delivered. I'm going to go through that in detail here. But the eviction timeline, especially from a tenant, read the notice. Very important. The notice kind of obligates the landlord has to be accurate in the notice given for termination. Certain things can be cured, non-payment of rent. Certain things cannot be cured, breach of the lease, illegal drug activity. And then the tenant should really appear in court. If they don't, they're pretty much going to be defaulted. Then the trial, there's under the court rules, within 10 days, there's supposed to be a trial or a hearing. And then after that period, after the hearing, there can be a judgment rendered. There can be appeal within 10 days. The appeal does not stop the landlord from getting possession unless the bond is posted. Very, very important. So that's kind of the way the eviction timeline occurs. Common defenses, we mentioned it, retaliatory eviction is a defense. If it's a rent case, full payment of rent would be grounds. Right? If breach of the warranty of habitability and repair is a defense, and fair housing violations are also a defense. If eviction is occurring because the family, for example, has emotional support animal or children or any other kind of discriminatory basis, that's a defense as well to eviction. I'm not going to go into the fair housing aspects. We do that quite a bit in other areas, but common eviction cases that mask underlying fair housing violations, non-renewal of tenancy, evictions for one or more rule violations, quid pro quo sexual harassment, domestic violence, emotional support animals, limits on the number of occupants. For example, if we had a case where a couple had a child, they were in a 1-bedroom unit, they're immediately given a notice that they had to move into a 2-bedroom unit or move out. That can violate familial status restrictions on occupancy limits. And it can also target disabled and other minority groups. You go through it, you look at who's, you know, who's being charged with rule violations, tend to be a certain minority group, not others. That's a violation as well. I would say this, the non-renewal is very, very suspect. I'll give you a recent example. It was involved, I won't give the property, but middle part of the state. A woman with a disability, and she's on SSDI and has family also help with her rent, was living in this unit without any problems for 14 years. Now she's being non-renewed. No reason given. So he said, well, you know, really feel that it's because of her disability. She has epileptic seizures in that, and maybe that's something that the landlord or management company didn't want. They want to go to more upscale demographics, things like that. But why is she being non-renewed? So what would you do in that situation? So I suggested two things. One thing is that it can be tested. So the Fair Housing Center in that community could then match up two testers or one tester with the same type of disability that she has to apply to live there and see what the landlord or housing provider says, management company says, see if they're willing to rent to someone else with that particular type of disability. If they don't, that's strong evidence. And then send somebody there without any kind of a disability and see how they're treated. That could be really strong evidence. Another suggestion is this. I said, you know, go for a 3 to 5 year period, go to the district court and determine whether they've non-renewed other people. And I think the attorney went there, he's online, he was able to find like, I don't know, 40, probably apartment complex, 40 instances in which the landlord moved to evict. Like all but 4 of them or so were for non-payment of rent. So he said, well, to get more information, I can't get more information than that without going into the court. They don't have that information available online. I said, go ahead and check. I doubt if you're going to see any rule violation or any non-renewal. What you're probably likely to see is for the cases that did not involve non-payment of rent, there's some type of rules violation or drug activity or criminal activity or something else. But I don't think you're going to find more than one, maybe not even one, where someone was just non-renewed for no reason. And that's how you prove it. So anytime I hear non-renewal, I think it's suspect. Now I can see a non-renewal when they're, you know, going to rehabilitate the premises, you know, rework all the units. That's occurring a lot. You know, people always want to get at the high rent, so they'll rehab a property, you know, make it more high scale. Yeah, I can see that. Or someone wants a tenant out because they're selling the property. Yes. But other than that, no. We have a discrimination complaint where the landlord owned 10 properties in a particular city, and the complainant was non-renewed. She has a disability. The landlord would not cooperate with her in getting zero funds. And then he said, oh, the two attorney, well, he's going to sell the property. It's been now over a year. He has not sold the property. He still has 9 other rental properties in that city. So again, non-renewals are suspect for discrimination. All right, let's analyze real quick with a complaint, an eviction complaint. Just highlight 2 real crucial provisions that are right on the complaint. First one is paragraph 3. It says, the person entitled to possession of the property described in the attached demand for possession is, and there's a name there they're supposed to put in there, and it could be the landlord's name, the owner's name, it could be a property management company. That needs to match up with the demand for possession. When I get a complaint like this, I do the same thing we did at the very beginning of this webinar. I go through the BS&A records, I'll go through the treasurer office, I'll go through register of deeds office to find out, are we really dealing with a proper plaintiff or landlord bringing the eviction complaint? Also want to know in the LARA records if that company is even licensed. I want to know if there's a rental certificate available. I'll come back to the rental certificate in a second. And so often the cases will get dismissed because they're not being filed by the person with the proper name. It has to be someone with the right to possession of the property. The management company does not have the right to possession of the property. They're a management company. They're not the landlord. They don't own the property. They're not leasing the property. All they're doing is assisting the landlord or owner as leasing the property. But who has the right to possession? The management company doesn't live in the unit. They don't live in any of the units. So many of the cases, I've had people say, well, I don't even know why we should raise that defense. Of course not going to care. Of course not going to buy it. And courts do. Courts do. Because the law requires it. The case has to be filed by someone who has the right to possession. Second thing, which is real important, it's right in the court form. It says number 7, must be checked unless modified by a lease. Again, you do not want a tenant to be responsible for doing repairs. That's a disaster. But here's 7 normally. Hopefully it's not in the lease. The plaintiff declares that this residential property was kept fit for the use intended and has been kept in reasonable repair during the term of the lease. The Michigan State Court Administrator's Office saw fit to type this requirement into the court form for an eviction complaint for a reason. When it comes to residential property, they're dependent promise covenants. The dependent promise is the tenant's obligation is to pay rent. The landlord's responsibility, dependent promise, is to keep the property fit and habitable. If they don't keep it fit and habitable, they have no right to collect rent. In commercial properties, it's a different rule. They're independent promises. Even if the landlord doesn't keep the property habitable in a commercial lease situation, the tenant still has to pay rent. The tenant then would have to bring a separate civil action against the landlord to get the property repaired and habitable. That's in the commercial side. Any court that does not follow this provision and require landlords to make sure that they kept their property habitable are not following the statute and are not following the state court administrative form. And someone came in, it was a third-year student from U of M, and she was doing work and writing a paper, a kind of a research report, a real big one. And she was covering eviction and the eviction prices. And I won't name the court that she went down to, but she went down to one of the district courts. And there were about 20 hearings that day for eviction, the eviction court. There are only 2 or so that even got on the record. Most of them ended up in consent judgments outside in the hallway. But she said when the ones that got into the court, the tenants tried to show that the property was not kept habitable, and those concerns were not addressed. She goes, how could they not follow the law? I said, sadly, that happens far too often. 36th District Court, people criticize 36th District Court sometimes unfairly, and they shouldn't. They set up, their web designer set up a real nice system where a tenant can take pictures and upload documents right into the court file for the judge to review. As long as it's done, I think, a day or 2 before the hearing. So it's very, very helpful, very user-friendly to make sure that that's done. Again, not being critical of all, some judges are very, very good at that, making sure that the properties are kept habitable. Another part with this is I would make the argument here, and I really wish it was in the court form, is that the landlord has a rental certificate. A certificate, of occupancy or rental certificate, whatever is required by the municipality. If they don't have it, then they shouldn't even be in the court. They shouldn't even have a right to collect rent. So this is very, very important. It's right there in the lease. And if I'm writing an answer to a complaint like this, I'll type out a lot when it comes to paragraph 7. I will type out a lot when it comes to paragraph 3. These are very, very important provisions. This cases can be won on these. Real quick, for eviction help, it's available. It varies. This is Detroit. I was asked where can tenants upload pictures for their case. I've never seen it or heard of it. That link is available for 36th District Court. Yes, I could. maybe in the Q&A section, I'll go and pull that up. This is, I just use Detroit. There's others. There's a variety of ones. It's, it's difficult because they're overburdened in terms of providing help. But certainly every tenant, to the extent they need help, should reach out to get that kind of assistance. Yep, I will look for it. If maybe Ingrid, Aaron, could you look at that, go into 36th District Court and put in the chat, put the link in where people can upload documents. I know we have it with our website, so it's something that is available, but hats off to the 36th District Court. I mentioned, I think, one of the judges or the chief judge about it, and what a great feature that was. And they weren't aware that other courts did not have that feature available. But what a great thing, isn't it? I mean, making justice available for people, it's just great. And people have things on their phone, right? And it works both ways. The option is for the landlord to respond and upload things that they want to show. That's fine. But just to make it easy for people to do it. But it shows the district court taking this provision seriously, that the property be kept fit and habitable. Real quick, anti-lockout statute. Types of violations, actual statutory damages, and so forth, how to bring a claim. Prohibits unlawful interference with a tenant's possessory interest. We talked about these. Use of force or threat of force. That's what gives rise to treble damages. Removing or destroying a tenant's property, changing locks, boarding of premises, removal of doors, windows, or locks. You'd think this is silly, but no. I have heard that where a landlord took a window out. Upset with the tenant, wanted the tenant to go, so they removed the window and just left it open. Would that send a message? Changing the locks. There's Shaw versus Castor was a good case on that. Introduction of noise, odor, or other nuisance. Again, if it's forcible ejectment, there can be treble damages. Other than that, there's actual damage for other unlawful interference. I do have Shaw. Yeah, I do have Shaw cited, Shaw v. Castor. It's a great decision to look at. But the Shaw is important because when it comes to actual damages, Shaw v. Castor, it's a federal court decision, but it's really well-respected, as Judge Cohn, very, very well-respected decision looking at Michigan law. In that case, he found liability for race discrimination as well as violation of Michigan's anti-lockout statute. And then he said, in that case, damages include damages for emotional distress, embarrassment, and humility are considered part of the damages for a lockout. So it's very, very important. Again, unless the lease specifies otherwise, the tenant is not required to pay for the rent if he or she is evicted by the landlord. The important thing is, well, when is the time for bringing the claim? The deadline for filing a claim under the lockout statute is 90 days after the time that the tenant was put out or becomes known to the plaintiff. They have 90 days to bring a claim to get possession back. For damages, it has to be filed, the case has to be filed in 1 year from the time the cause of action arose. So people have to make sure they file that in time. If they lose, where does it get filed? In circuit court if they've lost possession, because only circuit courts, generally speaking, have right for injunctive relief, equitable relief. So they have to file that in circuit court. They could join their right to damages in that court as well. And then for claim for damages can be included with the claim for possession, or it can be a standalone claim, and that can be brought in circuit or district court depending on the amount that's sought. Typically, if it's just monetary damages, probably that will be filed in district court. If someone is still trying to get back in the home, then they would probably go into circuit court to sue to regain possession as well as to get damages for the unlawful lockout. And there can be tremendous, yeah, I say if you go to 36th District Court, click services, upload electronic device. Yeah, I'm just trying to get the link. If you can copy the URL for that, where people can then do the upload. It's really worth looking at. Larry Landlord says that the anti-lockout statute is violated only if he changes the lock. Makes sense, anti-lockout, change the locks. Is he correct? What do you think? Is he correct? That's the only kind of violation? As if he changes the locks? What do you think? All right, I just put in the chat the link to uploading documents in 36th District Court. Very handy. I think you can you see it? Right here, submit electronic evidence. Make sure I'm sharing that. Yes. How do you like that? And you put the information in there, and it's just a great resource. Isn't that wonderful? Can't say enough about 36th District Court really helping people with that service. So is it, back to the question, is it only a violation of the lockout statute if he changed the lock? Or are there other things that can constitute an unlawful lockout? What would you say? What would you say? I'm not seeing people answer, but certainly it's more than just changing the lock, isn't it? It could be even introducing anything that would be a nuisance, anything to really drive somebody from living in the property. All right, so where do you go to get help? For landlord-tenant help, there's Lakeshore, Legal Aid, Michigan Legal Services as well, United Housing, Community Housing Coalition. You saw in the video, Ted Phillips, the head of that organization. There's Legal Aid Defender Association, Detroit Justice Center. An interesting one, which I'm not sure a lot of people are aware of, there's Self-Help, Michigan Legal Help. They've got forms that people can use to do it on their own. It's very, very helpful as well. Within the city, within Wayne County, Detroit, and others, Wayne County has a mortgage and deed fraud unit. Complaints should be made there. In the video at the beginning, they said that they didn't get a referral, so they didn't have anything to investigate, which suggests, hey, if we'd have gotten a referral, we will investigate any instance of mortgage and deed fraud. I know Oakland County has it. Probably all the counties do. They're aware of the problem, and they will take steps to address it. When it comes to housing discrimination, obviously our office is Fair Housing Center of Metropolitan Detroit, and there's a link for HUD as well as the MDCR if you'd like to file a complaint of housing discrimination. And these are the two resources that I mentioned. First is the Practical Guide for Landlord Tenants, and there's the link for it. And then there's the Residential Landlord Tenant Bench Book. That's located there for fair housing rights and responsibility. There's a link to HUD site for that. Of course, we have things on our website as well. But I can't say enough about those two guides, the Practical Guide and the Residential Landlord Tenant Law Bench Book. Well, both are very, very well put together, give a lot of guidance on this, and assist people in dealing with landlord-tenant issues. Again, it doesn't guide people necessarily in dealing with the fraud. That's why I spent quite a bit of time at the beginning of the webinar, ways that people can check to make sure that they're dealing with legitimate owner, landlord, management company and so forth to make sure that they're being checked out before somebody starts paying money only to be burned later on. And it's sad, right? That people actually can do it and someone else shows up. No, you got to go. Or they show up with the police. Well, you're a trespasser. I didn't rent to you. I didn't give you any keys. What are you doing here? So it's a horrible thing when that happens to a family who in good faith, moved into a home thinking that they could actually have the right to live there. Before we go into the Q of A, are there any things that you would like us, future training topics or anything else that you would like to know would be important to know? We really want to know what you think with this. When I talked about anti-fraud and that, it was identified by MSHA. After we came up with this webinar idea, I heard from MSHA that that's something that came up in their, I'm not sure if it was internal or external, but it came up that that's been a problem throughout the state with fraud and when it, especially as to rental situations. And MSHA put that down as one of their priorities to address. So I thought that's wonderful. We have something scheduled to seek to address this. But I do want to know any more topics. Be happy to do it. This webinar will be posted on the video, audio video will be posted on our website. So it'll be under services and resources or services. It'll be posted within a day or two. I'll have it up, the whole thing, so you can view it later. Also, it gives you a good opportunity. You can take a little bit more time, go through the slides. You can always stop it when it comes to a video on that, so that can be helpful as well. The way it works is we have a YouTube channel. We'll put it on the YouTube channel, and then you can access it through our website, and the website will then take you to the YouTube channel. So it's no problem at all for us to post it. But yeah, thanks. We need more information on retaliation and types of rental fraud. Yeah, that may be a more like advanced one, what constitutes rental fraud, and maybe go through some of the court decisions on that would be helpful as well. Real quick, our services, we do housing complaint intake and housing complaints, both discrimination and housing related complaints. We do intake investigations. We do fair housing testing, enforcement, and resolution. All of it's provided free of charge. We answer other housing questions. We do research in that. We do training and education. And please feel free to contact us either by phone, 313-579-FAIR, or on our website, fairhousingdetroit.org. And I want to thank you for participating. I'm going to stay on while we go through and answer questions that you may have. All right, thank you so much for participating. I'm really glad. We have another training session coming up. This one's dealing with source of income, efforts to have that adopted by more municipalities as source of income protection. Hopefully, eventually, the state of Michigan will adopt source of income protection. There's a number of people with vouchers that can't find housing because people are not being rented to a source of income. There's also situations where people are attempting to purchase homes, and because they have FHA and VA financing, they can't get, are not able to purchase homes. There's also issues that the people with SSI and SSDI not being able to obtain housing. There's also kind of artificial or unfair barriers to housing. For example, some housing providers, landlords requiring that someone show that they have an income of 3 or 4 times the rent amount, which does not make sense if someone's on a voucher, does not make sense if someone is on SSI or SSDI. That's very, very stable income. They're probably not going to be able to show, gross income or monthly income at 3 or 4 times the rent amount, but it doesn't mean they could not be able to afford to live in the unit. And so hopefully at some point, source of income is continuing to be adopted, but it will finally be adopted by more and more cities and eventually by the state. Already we're up to, I think, 20 states in the nation that have adopted it, but we need more. We need more in Michigan so that those that are low income will have the access to housing that they need. But anyways, thanks again for participating. And again, I'm going to stay on right now and then we'll answer more detailed questions, kind of an off the record. There'll be no recording, and then you can speak freely. We can speak freely, answering questions that you have. Thank you again, and I really appreciate you joining us in our training today. Thank you.